Tēnā koutou katoa, no mai haere mai ki tēnei webinar or the pursuit of utility justice, an activist scholar perspective. I'll just open us with karakia. Hinoi tātou. Tui ai runga, tui ai raro, tui ai roto, tui ai wapo, tui ai te here tangata, ka rongo te pō, ka rongo te ao, haungi, hui e, tā i ki e. Tēnā koutou, ko Carl Chenery tōku ingoa. I'm your chair for this session. It's great to have you here with us. You are in the right place. Just bring you on to some housekeeping before we jump into the session. Here is our community code for our questions and Q&A. Later on, we're curious, open, respectful, make generous assumptions, speak from our own experience. We know no one knows everything together. We know a lot. Can't all be articulate all the time, although we've got some amazing speakers during this overall session. So this is our community code. Just coming on in terms of accessibility info. Kate's going to put this into the chat for us, but live captioning is available for this session. And so just leave it there for a few more moments for introducing our guest and speaker. Welcome, David. Great to have you here. Just share. Kia ora, David. So David Williams is a Professor Emeritus at Waipapa Taumata Rau, University of Auckland. He's got tertiary qualifications in history, law and theology, and a PhD from the University of Dar es Salaam, Tanzania, where he taught in the 70s. For 46 years, he was an academic specialising in research and writing on law and society and legal history. He's an honorary fellow of the American Society for Legal History and a fellow of the Royal Society of New Zealand, Te Apārangi. Just jumping into it here, David. In the Citizens Association for Racial Equality Care, he was a political activist on issues affecting Māori and Pacific peoples during the 1970s and 80s. From 1992, he was an independent researcher specialising in research relevant to Te Tiriti o Waitangi claims. In March 2023, he was appointed as a member of the Waitangi Tribunal Te Rōpū Whakamana I Te Tiriti o Waitangi. Kia ora, David. Great to have you here.
Tēnā koe Carl. E ngā mana, e ngā reo, rau rangatira mā o te motu, o te ao whānui, a tēnā koutou, a tēnā koutou, a tēnā koutou katoa. Ngā mihi o te wā ki a koutou, ngā participants, 128 of you at the moment, and those who will follow looking at this at a future date. Kia ora to you all. No mai, piki mai, kaki mai ki tēnei kōrero I rau I te waro o Te Tiriti o Waitangi, he kawanata tapu I Wainganui a tātou ngā iwi Māori, ngā iwi Pākehā o tēnei motu o Aotearoa. So kia ora to you all, and thank you to the people behind the scenes who are making these things possible. And it's over to me to start, I think, Carl. Is that right? Explain myself.
Yeah, I'll just let people know that there are there's opportunities to ask questions in the Q&A tab at the bottom and also in the chat. So as we're going through, feel free to pop those in. We'll have a chance at the end to answer questions. But yes, I'll hand to you, David.
Okay, so what I agreed to talk about was being an activist scholar. And I think the message I want to get across is that I've had many decades of involvement with Treaty of Waitangi issues, and always I've sought to be one of the people who are allies to Māori that are raising the questions about the way in which our governments successively have dealt with Māori and are continuing to deal with them or not deal with them on occasions. So I think part of my aim today is to encourage people to make a lifetime commitment to engage with the treaty. And this whole program that you're part of today and the next few days is has that kaupapa of people being engaged. But if you're engaged in something, you don't necessarily stay rigid and stuck in any one position. One of the very interesting things that I've found is that I've been consistent in my engagement with the issues, but the way in which the issues get presented has changed a good deal from time to time. I got that experience of teaching in Dar es Salaam in East Africa as my first job in a country which had only got independence less than 10 years beforehand, at the only university in that country, and all of the students that I taught were people who were going straight into significant positions in their country, which at the time was one of the leaders of the anti-apartheid solidarity of African nations. Dar es Salaam was the headquarters for the Organization of African Unity Liberation Committee, as it was at that time. And many, many people came to Dar es Salaam, and often they came to the University of Dar es Salaam to share their thoughts about important topical issues. And apartheid in South Africa, racism in Rhodesia, and the continuing imperialism of Portugal and Angola and Mozambique were very, very high on the list of people's priorities. And of course, the question that I would always get was, where does New Zealand stand on these things? Well, New Zealand in those days stood solidly in support of South Africa on crucial occasions, frequently. And so when I came back to New Zealand, I made a commitment to engage in anti-racism struggles. And I did some work on a PhD, which I later completed at Dar es Salaam, on comparing the imposition of colonial rule on Aotearoa with the imposition of colonial rule in the Tanganyika mandated territory, which the British took over after the Great War, the First World War. It had been a German colony beforehand. And at the time, following the Māori language petition of 1972 and various activism events organized by Ngā Tamatoa and Waitangi Action Committee, the slogan that those of us who joined with them used was, "The treaty is a fraud." Now, these days we talk about the treaty as either the foundation of our nation, or at least it should be a foundation of the nation, or it already possibly is a part of the foundation of the nation. So it may seem odd to those of you born in more recent years to think that those of us who were activists were shouting very loudly that the treaty is a fraud. Not only shouting that, but getting badges and remembering that the treaty is a fraud. So this all comes from being engaged with struggles like the Bastion Point struggle, 1977 and 1978, with ongoing struggles to free Nelson Mandela, who was in Robben Island as a political prisoner, which went on to finish up with a whole lot of demonstrations, and I got a few criminal convictions out of trying to stop that tour in 1981. So I'm that sort of an activist. I'm a political activist. And how does that then inform my academic work? Well, my PhD essentially, half of it was to do with Tanzania, but the half to do with Aotearoa, New Zealand, was going through some of the materials and the records and the archives and the articles that historians and lawyers and others have written in the past, and say, well, exactly how did this country come to be a British colony? The answer then wasn't all that clear, and it still isn't actually, as to exactly who, actually which basis of of colonial justification was the appropriate one. And I went through what European scholars and international lawyers who always operated out of a Eurocentric framework, what they said. Well, it has to be conquest. Well, there was no conquest. Has to be cession. Well, was there a cession of sovereignty by Māori? Well, that didn't seem to be at all what the Treaty of Waitangi looked like to those of us engaged back in the 1970s. Was it just occupation following discovery? Well, New Zealand was discovered, if that's the right word, by Europeans from the Netherlands who never set foot here. There was a cartographer in the East India Company that gave us our name, New Zealand. Nothing to do with Abel Tasman, nothing to do with Captain Cook. So that didn't seem to be a justification. So my conclusion was that it was merely a usurpation. It was a British usurpation, a British takeover without any justification in British or international law. And that entirely suited the slogan that the treaty is a fraud. And as I'm finishing this thesis, I lodged it, I think, in 1982, and then in 1984, it was finally awarded after a process which, if you remember, is before telecommunications of the sort that we have now. You know, great bulk of theses have to be posted from one place to another, and examiners have to read it, and so on. So it took a little while. So by 1984, when my PhD thesis was bestowed upon me by President Nyerere, who was the Chancellor of the University of Dar es Salaam, I was already shouting a different slogan, because 1984 was the Hikoiki Waitangi from Ngaruawahia to Waitangi, at a time when leaders like Eva Rickard and many of the leaders of Kingitanga decided to raise this issue of the recognition of the Treaty of Waitangi really seriously. And so the slogan then became, honour the treaty. Well, first it was stop the celebrations. Well, that seemed like a good idea. But then it was honour the treaty. So now some of my friends said, weren't we shouting a couple of years ago the treaty is a fraud, and now we're saying honour the treaty? So how come that has come to be? And the answer to that is that historians and lawyers finally picked up a message which had been around for a long time, in particular from Ruth Ross in her article in 1972, which was very critical of the treaty-making process and said the treaty probably didn't count for anything at all. But if it did count for something, it has to be the Māori text. Now, most of us forgot about the idea that the treaty shouldn't count for anything, but we did pick up her idea that the Treaty o Waitangi in the Te Reo text was the primary text of the treaty. The language of all of the negotiations, even at the one or two signings where an English text was used, was all in Te Reo, and weight should be given to that. So that's stage number two. First, stage number one, treaty is a fraud, academic work to justify that. Now, academic work to honour the treaty from 1984 onwards. That Hikoiki Waitangi in 1984 was highly influential on some of the members of the opposition at the time, the Labour Party. They were elected later in that same year to become the government. Geoffrey Palmer in particular put forward some legislative changes, which included giving the Waitangi Tribunal the power to look into historic claims. That was done in 1985. And so we've now got in the law, there's the text in English and Māori in the Treaty of Waitangi Act, setting up the Waitangi Tribunal. What then happened is that successive governments really forgot about the treaty itself, forgot about either text of the treaty actually, gave up quoting the English text as the only text. That was at least an advance, but turned their attention to the principles of the treaty, a phrase which was originally used by Maturata, the first Māori to be Minister of Māori Affairs during the Kirk Labour government, third Labour government, 72 to 75. And after 1987, when the Court of Appeal court case stopped the privatisation policies, corporatisation policies, which then later became privatisation, the focus was on, well, what does these principles mean? And so by that stage, I then became a critical legal scholar in terms of upholding the Treaty of Waitangi, Te Reo text, as primary and as different from the English text, as Ruth Ross had argued, and I supported her at that time, and trying to move our legal system from a mono-legal system based entirely on British and English law to accept some of the arguments that had been put forward at that time by Judge Eddie Durie, now Tai Hakure Durie. He was then the Waitangi Tribunal chairperson and has since been in the High Court and is now retired. And he put forward the notion that we are, in this country, Tangata Whenua, the original people, and along with Pākehā and others who've come after them as Tangata Tiriti, who belong to the land by right of that treaty. So it's the treaty that should be at the forefront. So that seemed to me really important, but most people were going along with the principles. They said, well, these judges have come up with some principles. And then a large number of principles get enunciated, both by the Waitangi Tribunal in its reports, and by the courts, and many statutes, acts of parliament were passed, which gave rise to further elaboration of what the principles of the treaty might be. And almost all of those principles were established without any reference whatsoever to the actual wording of the debates by Māori at Waitangi, Mangungu, and all the other places where the treaty went. And the words in Te Reo, they seem to be forgotten in talking about partnership and good faith and all sorts of other concepts drawn primarily from reasonably pleasant concepts available within English law, but showing no reference whatsoever to tikanga Māori, or ritenga Māori, kawa, none of those indigenous concepts that I believe Ani Makari was probably talking about earlier this morning. They weren't looked at all, just the principles. And so I was one of those that said that's an inappropriate pathway. And another inappropriate pathway was the doctrine of Aboriginal title. Now, if you're Māori and you want to win a case, you've got to put forward arguments. If you want to win a case in the state courts, you've got to put forward an argument that judges in the state courts are likely to accept. And so there was this thread of thinking about Aboriginal title that came from the United States Supreme Court, which said that when Europeans discovered a place, they could take it over. That's the sovereignty bit. But they also had to acknowledge that the Indigenous people had some existing rights, which should be protected until such time as they were fully extinguished. And my question always was, well, who gave the Crown in New Zealand or Canada or Australia, who gave the governments of those British Commonwealth nations, as they were then, the right to decide what Indigenous rights were? And so I thought the doctrine of Aboriginal title wasn't a very good one. And one of the main reasons why it wasn't a good doctrine is because it's based on this notion of discovery. This is not discovery as per what popes said to the Spanish or the Portuguese or other imperialists. The British imperialists were not very keen on the Pope, actually. The British imperialists were Protestants and didn't much like anything Catholic at all. But they did like the idea of discovery doctrine. They drew on, many judges have drawn on statements from a United States Supreme Court in 1823 called Johnson and McIntosh. And then that was applied in New Zealand in a case called Simons in 1847. And some people think of the Simons case as a praiseworthy case. And I've always criticized it because of its origins in the doctrine of discovery. You can only define Māori rights in terms of imperial constitutional law drawn from United States precedents, then that's not the way to go. So I was a bit of an outlier there, and I kept on saying that that was inappropriate. The principles keep on being developed, and all sorts of people get to work on it. And then some people came up with the 3 Ps, and I never liked them. I can't even remember what the 3 Ps were, but partnership and something or other and something or other. And again, that's not something that I thought we should engage ourselves with. We should just get back to the treaty itself and investigate what exactly Tino Rangatiratanga meant. And who do you ask as to what Tino Rangatiratanga meant? Well, you ask the Rangatira that. You find out what people with knowledge of Tikanga Māori, what people with knowledge of Mātauranga Māori, what people with knowledge of how the kawa works from one place to another around this nation. You find out from them what they thought that concept might mean. And as many of you watching this will know, that was definitely a position that Ngāpuhi, who see themselves as the original source on these matters, because after all, theirs was the first hui on the 4th, 5th and 6th of February of 1840. And then Mangungu going across towards the Hongianga a day or two later, and then many other signings in about 39 different places around the country. Well, did Tino Rangatiratanga sound at all consistent with an absolute cession of sovereignty to the Crown, which is the wording in the English text? And most of us said no. Most of us who engaged with those issues in support of Māori said that doesn't make any sense at all. Tino Rangatiratanga has to be understood in terms that made sense to those that agreed to put their marks or their moko or their signatures on the Treaty of Waitangi in the 9 sheets of the treaty that were signed between February and September of 1840. But then move on a little bit, and I have to change my mind again. Treaty was a fraud originally, stop the celebrations, then no, honour the treaty, honour the Māori text of the treaty, forget about the English text of the treaty. And then I get a student who comes along and does a PhD under my supervision called Ned Fletcher. And Ned Fletcher had the time to spend a lot of his time in archives all around the world, but he looked at lots of material on what the British thought that they were asking for when they asked for cession of sovereignty in 1840. Most people have defined sovereignty, even in the Waitangi Tribunal hearings in recent years, in ways that were not what the British had in mind in 1840. Because in 1840, the British were quite busy taking over bits of the world and imposing their imperial rule in various places in the world. The Dutch were doing quite a bit of that. The French were doing quite a bit of that. The Spanish had already done quite a lot, and the Portuguese as well. So the European empires, and then the Germans came late, and they said, "Hell, what's left for us?" Did a little bit of a rush for Africa after the Congress of Berlin in 1878. So all of those activities were based on the fact that Europeans had the right to go around the world and take over colonies, but they were quite untidy about what was actually the precise justification for it. And they didn't always just come in and impose their own law of Britain on British territories, because there's many parts of the world where British settlers didn't want to go, but the British government did want to rule those places because they had resources, which the British Empire wanted to get hold of. So rather than directly rule the populations that they acquired by force of arms or by whatever means, the idea of protectorate came up, and the idea was that the British would protect the local people and would not change their rules and laws and customs. They would leave the native courts, as they were called, in place, and leave the native chiefs, as they were called, in place. So a system called indirect rule, and that's what applied in Tanzania. So that's how I knew about that system from the past. But what Ned Fletcher drew to my attention over the 7 years that we were engaged in his thesis, which has since been published in the book called The English Text of the Treaty of Waitangi, is that the 3 or 4 people who were the British people who were key to the instructions to Hobson and then the treaty that was written under Hobson's orders in 1840 were entirely consistent with the view that what the British wanted in New Zealand was a colony where the British government could protect Maori from the rapacious settlers that looked keen to come. And in particular, the British colonial government at the time in 1839 to 1845 wanted to stop the New Zealand Company. They didn't want the New Zealand Company to come. They tried to stop them. And when they did come anyway, regardless, in direct violation of the orders of the British government, when the New Zealand Company came anyway, the insistence by Hobson and his superiors in London was that the Treaty of Waitangi had given Hobson the power to control British settlers. But that didn't mean that Māori lost their rangatiratanga. It didn't mean that they lost their tikanga as the first law of the land. It meant that the British settlers had to be under the British Crown. And so the New Zealand settlers in Wellington, 21st of May, 1840, they'd set up their own government for the New Zealand Company. And Hobson said, "No, that's not on. You're British settlers, and I, on behalf of the British Crown, insist that you are under my authority, not under your company's authority." And lots of arguments went on between the first and the second governor and the New Zealand Company, and lots of long letters were written. But what Ned Fletcher made pretty clear was that the cession of sovereignty for the Crown to have control over British settlers did not mean that the Crown intended immediately to get rid of the rangatiratanga exercised by the rangatira of Hapu around the Motu. And so that's the sort of the next stage that we've reached now. And some people think there may be some inconsistency between the Waitangi Tribunal's Y1040 report and Ned Fletcher. No, there's not, because what the Y1040 report for Ngāpuhi, Nui Tonu, concluded was that Māori never ceded their sovereignty, if by sovereignty you mean that Māori lost control of their own affairs and lost the right to continue to conduct their affairs within the within the values and conflict resolution models of kaua and tikanga within Ngā Hapu or New Terrain. So, so as of about 1840 to 1845, where you get to is that Māori were to be protected. Now, that's all sort of imperialist thinking. That means that the British are there being imperialists, of course, and are deciding the parameters. But it doesn't mean that there was a cession of full sovereignty. The current position of Crown Law Office in recent tribunal hearings, including that Y1041 from Ngāpuhi, is that the cessions in 1840 were of full sovereignty, so that English law would sooner or later, and preferably sooner, be imposed upon Māori. That the rangatira would indeed lose their authority, that police and judges and courts would have authority over Māori. It took a little while to work its way over the whole country, of course. It didn't all happen in one blink of an eye in 1840. Many areas like Kingitanga in the King Country and Te Urewera and other parts of central North Island continued to be Māori autonomy areas for a very long time. But after the 1840s, the die was cast from colonial thinking point of view, and tikanga was suppressed. So many breaches of the treaty, of course, followed. Probably the biggest one, in some respects, was the New Zealand Constitution Act of 1852, which set up a settler-controlled government at a time when Māori was still the majority of the population, and gave Māori no rights to vote because you had to own property, and most Māori, well, virtually all Māori except for a couple of dozen, owned customary tenure Māori land and didn't own fee simple European title land. I can't say too much more about that particular constitutional issue because the wheel has turned, and from being that activist scholar, shouting all those slogans and marching to Waitangi on countless occasions, in my retirement, the government has seen fit to appoint me to the Waitangi Tribunal, as Carl mentioned at the beginning. And I am now on a Waitangi Tribunal panel that is looking at constitutional issues and indeed looking at whether urgency should be granted to a hearing on the Treaty Principles Bill sponsored by the Coalition Act, New Zealand First and National Parties. So from when you want to ask me questions, I'm afraid I can't answer those questions because people who are on the Waitangi Tribunal, like judges, we've got to wait to hear the arguments that the Crown will put up. We've got to wait to hear the arguments that the claimants will put up, and then we'll offer our opinions through a tribunal report. So ask me about anything you like, really, from 1974, shouting the treaty is a fraud, through to my supervision of Ned Fletcher's thesis, and I'd be very happy to explain just why it's quite important to keep on looking at the evidence and changing your mind if you think the evidence requires you to change your mind. So lay down your own personal kaupapa, support the treaty in one way or another in all the different ways that are open to the different people who are interested in these topics. And we're up to 181 participants at the moment, I see, and about 39 things in the chat. So maybe I should turn over to Carl or someone or other else to get those chat opportunities available to you. So there we are, a critical scholar. I'm now on the dark side. I've been appointed by the Crown to be a member of a tribunal, and I'm looking forward to it. Don't ask me questions about that, just ask me questions about all the rest of it. So e hōma, kia ora koutou, kia ora koutou, kia ora tātou katoa.
David, ngā mihi nui ki a koe. Thank you for your dedication and activism and scholarship over the decades. The chat is full of appreciation Awesome insights, humble and honest. There are a few questions here. Some of them can be answered in relation to historically, and as you've already said, you can steer away from the current question. So there's one question here from Dini Moehu, which is, what are the most significant legal challenges or obstacles in achieving Te Tiriti justice?
Well, the thing is, Te Tiriti justice, align that with the current slogan, which is Toitu Te Tiriti. It's an all-encompassing thing, and so in many ways, in the past, a lot of activism and a lot of the way in which these issues have been argued tends to be reactive. So one example would be the foreshore and seabed. So foreshore and seabed issues are raised by the 8 iwi of Te Tauihu, or Te Waka o Maui, the 8 northern tribes of the South Island, who are concerned by having councils, both regional and district councils, that would refuse to give them any right to use foreshore and seabed areas in the Marlborough Sounds and elsewhere for aquaculture. They would consistently be turned down. They said, damn it all, we're going to go to court and we're going to find out if our customary rights still exist. So they go to the Māori Land Court, and Judge Hingston says, well, it looks like you might have some customary rights. So we'll set down some hearings to consider whether you do have what's the precise parameters of your customary rights in the foreshore and seabed area. So the government of the day, the Labour government of the day, wasn't very keen on that, and so the government launched proceedings in the High Court to have the Māori Land Court decision quashed. It's rather important to remember it was the government that started that litigation. The case is called Attorney General against Ngāti Apa and the other iwi of the South Island, Northern South Island. And the government lost that case, and they appealed to the Court of Appeal, and the Court of Appeal, with Chief Justice Sean Elias and 4 other judges in what's case is usually referred to as the Ngāti Apa case, said that Māori customary rights exist unless they have been unambiguously extinguished, and they hadn't been. So the government at that stage then says, oh, well, we don't like this litigation process, it's not going our way, so let's introduce an Act of Parliament to overrule it. Well, that's when the reactive bit comes in. Perfectly reasonably, many Māori and a few allies got really upset, and the Hikoi Takutai Moana came from the far north and from the Tairāwhiti, led by people like Hone Harawira, Hinda Haukiard, Miriama Pittman, and others. And so that's very good and useful reactive politics. Actually, on that Hikoi, I met Hone Harawira at Wellstead, and I had that badge on, and because I thought that what the government was doing was really saying the treaty is a fraud. And Hone looked at me and he said, bloody Williams, how many people have still got an original copy of the treaty is a fraud button? But anyway, I have, and I still got it there. So that's reactive politics. What I think is happening now, and which might address the partai that you just put to me about achieving treaty justice, is that all of the hui, a couple of which I've attended this year, about the issues that have arisen since November last year, are very much about Māori getting on with promoting mana mutahaki, getting on with standing tall for tino rangatiratanga, getting on with being Māori, following the words of Kingi Tuheitia at Turanga Waiwai. And even the haka by the women from the Hurricanes is saying, well, governments are temporary, but the treaty is permanent. And isn't it great that we live in a country where a women's rugby team can engage us in the issues that are going on at the moment? So I think my response to the question is that this obvious treaty justice is something that obviously must be Māori-led, and the consensus of kotahitanga within Māoridom, the better. And the rest of us, tauiwi, those that are the Tangata Treaty, those of us who've got the right to be in this land only because of that treaty, need to find our own ways to support that, rather than just being reactive to everything that the government does from time to time, because governments do come and go, and sometimes you can't even notice the difference between the one before and the one after, but maybe it's a little bit different this time around, but on that one I won't answer further, because I will have to do that on the tribunal itself.
Good, David's other questions here. What is the jurisdiction of He Waka Putanga? What jurisdiction does He Waka Putanga have today? Another question is, what happened to iwi that didn't sign either documents? What jurisdiction does the government have? Again, lots of limitations on your answers there, but.
Yes, those that either didn't sign the treaty because no one ever asked them, or who were asked and refused, that's always been a really interesting question, and it was the fact that the British government in 1842 insisted that British sovereignty had been proclaimed over the whole country, even if signatories to the treaty couldn't be found in the whole country, is one of the main reasons that I concluded in my PhD thesis that the treaty was not the basis for the claims to jurisdiction made by the British Crown. The lawyer's answer is to go to the Native Rights Act of 1865, which declared that all Māori were British subjects, whether they liked it or not, and should be treated as British subjects. So that's just an assertion by the colonizer through the settler parliament. That right to be treated as British subjects in the context of 1865 included the right to be executed for being a rebel, if you call that a right. So what the settler government was doing in the war period in the 1860s was insisting that British sovereignty applied to all people. Didn't matter who they were, where they came from, and in particular it included all Māori people. For those who want to argue for treaty rights for those who didn't sign, say, well, if other people got rights, even though when they signed, then we should get the same rights because the settler parliament imposed the status of being British subjects upon us. And if we're British subjects, we at least surely should have some rights under that system, because it was called the Native Rights Act of 1865. Well, that's a very, very poor answer I've given, isn't it? Who wants to rely on a war period 1865 statute for imposing British rule on those that didn't sign the treaty? So those that come from hapu that didn't sign the treaty, in many respects, you're in the same position as those that did, because you never ceded your sovereignty in any way at all. Not sovereignty as we now understand it, as full imposition of authority of the present government over everyone. But then neither did those that did sign the treaty. So in some ways, it doesn't actually make a big lot of difference. The claims for mana motuhake apply to both. I think that's the gist of the answer. The claims to mana motuhake apply whether your ancestors were treaty signatories or were treaty non-signatories.
Good, David. Further question here. As an anti-racist activist scholar, what are your experiences of white-on-white lateral violence in your work towards tiriti justice? I don't think it's a certification for airing dirty laundry, but maybe it's a question about, what your experiences of that, or how can...
So can you just repeat the gist of that bit? White-on-white?
White-on-white lateral violence in your work for tiriti justice over the years, about how Pākehā can work against each other and supporting tiriti justice.
Yeah.
There's a kind of related question further down, which is about I'd like to ask you how to use your words to address other Pākehā and how entrenched intergenerational views, without speaking for Māori or addressing what they know from their own lived experience, how do you address racism amongst Pākehā or Māori in the room?
Yeah, well, so just going back to my early days as to how I got involved in some of these issues as an activist scholar. University, the laws setting up universities say that university academics should be critic and conscience of society. It's still there, and I took it seriously. And back in the 1970s and early 1980s, there were very, very few lawyers that wished to get involved in Māori issues at all. But people like Joe Hawke and Eva Rickard and Nanako Manhunik, whom I worked with, let it be known that there was at least one lawyer in the university who viewed his salary as the only thing he needed to support him and his family, and he'd give free legal advice if you wanted it. And so I was one of those that made myself available to write some of the early statements of claim and so on, and including for the Bastion Point struggle for Takaparawhau. So I've received a fair bit of backlash over the years for some of the stands that I've taken, and there's a sort of a song that goes something like, life wasn't meant to be easy, life wasn't meant to be free, life wasn't meant to be easy, I'm sure that Muldoon would agree. And so sort of Muldoon was our pet enemy in those days, and he stirred up a fair bit of hatred, actually, of those of us Pākehā stirrers who were raising all sorts of issues, and we were all just communists in disguise and all sorts of stupid statements that were made quite regularly by people. So over the years, there's always been those that are prepared to be quite critical of Pākehā people standing up for Māori rights. But I've always had to be absolutely clear that I am a Pākehā. I am not a Māori. I'm not speaking for Māori. I've got no whakapapa Māori. And then they say, yes, but you've been involved in all these issues. So what do Māori think about such and such? And my reply has always been, well, what do Pākehā think about that particular topic? And the answer usually is Pākehā have quite a few different views on that particular topic. So I say, well, why do you expect Māori to have exactly the same views on any particular topic? And I guess I guess that in the situation where we have now, where we've got Crown institutions in Parliament that once upon a time only had just 4 Māori MPs. They were the only Māori in the House of Representatives. That entity is still a Crown entity. It's still part of the Constitution with the Queen, or the King, sorry, as the King of New Zealand, and the Crown as the Crown in Parliament. There are, of course, quite a large number of Māori in Parliament, and there's quite a large number of Pākehā. but whether they're Māori or Pākehā, they're still in a Crown institution. What are the ways in which treaty justice can be achieved is still a live issue, regardless of how many Māori were in the present cabinet or the previous cabinet of last year. It's the institutions that we serve that's important. I guess I've been willing to just face up to attacks. I know. I think I might have an answer for that question, which has now come to me. There was an occasion when Hannah Te Hemera, came to a hui at Waipapa Marae in the University of Auckland, which was then quite a new marae complex, Tanenuarangi, the meeting house there. And Hannah and a couple of other people had just been to maximum security prison at a time when there'd been quite a number of suicides by Māori in prisons. And Hannah was expressing her despair about the way in which incarceration was affecting young Māori, and so much so that they were willing to take their own lives. And she said, I almost would want to say, look, at least why don't you kill a white before you die? And that became a massive headline. And a whole lot of my law faculty colleagues walked out from that hui. And they said, well, we're not going to put up with that racism and us being called racists. And in the conversations afterwards, several of my colleagues said, so David, they called us all racists. I mean, how do you cope with that? Because you're not a racist, are you? I said, if you've lived in this country, grown up in this country as a Pākehā person of white privileges, I probably wouldn't have used the word white then, of Pākehā privileges, and you haven't been called a racist and been a person who's got privileges from a racist system, then you haven't lived in this country. You haven't really known what this country is based on, because it is based on privilege, that is colonial privilege that's been passed down. And so people like myself often get called agents of racism. And in a sense, we are. Well, that wasn't something that my colleagues were prepared to listen to. They just all they wanted to do was just to focus on that one phrase that Hannah Te Hemera had said. They didn't want to inquire into incarceration policies. They didn't want to inquire into the proportion of Māori in prisons. They didn't want to look at all of those racist colonial institutions. They just wanted to look at personal attack on themselves as being racist when they said, we're not racist. Well, that's one way in which the issue has come up in a very strong sort of sense.
There's quite a lot of questions still in the chat, David, and we're coming up 5 minutes before the end. I'll just ask this question. In regards to changing your mind and slogans over the years, how much has this been due to Māori political actors who've had relationships changing their minds and your following? Or have you found that you've changed your allegiances to different Māori political actors over time?
I think I've usually followed the people whom I got to know back in the day when we were all involved in anti-racism struggles between the mid-1970s and the mid-1980s. And they have influenced a wide range of people. And I've always said that one of the great things about being a Pākehā ally is that once Māori have achieved a particular goal, which in the case of Ōrākei was getting their land back, their whenua at Ōkahu and Takaparawhau, I leave it up to them to sort out any issues they have. So they had two amazing leaders, Sir Hugh Kāwharu and Joe Hawke, who disliked each other quite a lot, and had lots of arguments. And I said, well, I don't get involved in those arguments. So those are your arguments. So I've always sought to work out what is the kaupapa, and the kaupapa there was to get the land back, and the way of getting it back, that different people, different Māori had different ideas, but support the kaupapa. I think, though, that the supervision of Ned Fletcher was a bit different, because that was really a scholastic journey, which took me to a different place without any particular connection with the Māori people who I've always worked with and tended to support.
Kia ora. And one last question. What advice would you give to tangata tiriti activists supporting Tino Rangatiratanga today?
Well, the first thing is to be active and choose what your own skills are and the best ways in which you can exercise your talents. But also, I'm afraid it's going to be a long journey. This is not something that capitalists and Pākehā people in power, mostly Pākehā men in power, are probably quite likely to want to keep some of that power, or possibly keep all of that power. So there's also the need to have some joyful times in your life, and not always just be engaged in struggle and then give up because it all becomes too difficult. So moderate your journey so that you can cope. You can have relationships with your friends and partners and families and so on, and find that some of them are very different from you and your viewpoint, and you'll choose your time to raise the treaty issues which they don't like, but you'll do it as conscientiously as you can, and just be true to. There was a phrase we used once, was honourable kawanatanga, that tangata treaty people who are allies of Māori Manawatu Hake claims, have to do our best to be a people who wish our government to be an honourable kawanatanga and not a dishonourable one. You have to do that day by day, year by year, but do it in a way so that you're going to survive rather than just give up.
Kia ora, David. Really grateful for sharing of your insights. There's a lot of gratitude in the chat and in the questions for your kōrero and your commitment over the decades. I'll put a few links up. We're going to update these into the chat, into the video description after, for you to go and have a further look. Some of the resources there you can go through and have a look. And some of more detail into some of the stories that David has shared. I really want to thank the partners for Tiriti-based Futures, 30 partners that are up here on the screen for all their work, for the volunteers behind the scenes. Coming up to Kei Te Mura o Te Ahi, a Marathon for Racial Justice, is on the 22nd of March, so keep your eyes out and sign yourself up for that. Really, I'll just, anything else you want to say, David, before we close up?
I've just noted that Kate, as moderator, said we don't have time to answer the questions. We'll be sure to pass them on to me. So I think that's important to me, and we'll see if there's ways in which I can respond at some point. But at any rate, I would be. I'm keen to get off to the World of Music and Dance in Ngā Motu, New Plymouth, and I'm going to go there now. But I would really like to honour all of those questions that didn't get answered, and do my best to respond if there's a way of doing that. So kia ora no koutou katoa.
Kia ora, David. We'll make that happen. Let's close this up. Okay, no tātou. Kia whakairia te tapu, kia wātia ai te ara, kia tūru ki whakataha ai, kia tūru ki whakataha ai, haumie, hui e, tā i ki e.
Kia ora.
Tōra tātou.